In today's gripping courtroom moment, tension reaches its breaking point as a judge loses patience after the defendant's third violation. What began as a routine sentencing quickly spirals into an emotional standoff between law, defiance, and frustration. Stay tuned, because what the judge says next shocks everyone in the courtroom.
Cuts.
Thank you, Your Honor. We are here today in 4 separate cases entitled State of Ohio versus Crystal Facemeyer. Those case numbers being 19 CR 001297, 20 CR 000065, 24 CR 001178, and 25 CR 000368. Defendant is present at open court today with her counsel, Eric Cherry. Your Honor, we're here today on probation violations on the 2019, 2020, and 2024 case. Defendant previously waived probable cause. State's understanding that today she will waive final hearing, plead guilty to the violations, and proceed to sentencing. We're also here for sentencing on the 2025 case, where she pled guilty by way of information on May 7th of 2025 to 1 count of theft of drugs of felony of the 3rd degree and 1 count of theft of felony of the 5th degree. At that time, an updated pre-sentence report and victim impact statements were ordered. It's the state's understanding the updated pre-sentence report was completed and provided to the court, and that all parties are prepared to go to sentencing at this time.
The violation in the 25 case, is it because of the conviction in the sentencing in the 24 case?
There is no violation in the 2025 case because that's just a sentencing, but it is one of the bases for the violations in the 24, 2020, and 2019.
All right. So she's already pled guilty in the 19 and the 20.
That's from a prior probation violation.
All right. I'm not even going to monkey around with that. Okay. We're going forward on the 25 case. Is there a violation filed in the 24 case?
Yes.
What's the violation?
The violation in the 24 case is 1, 2, 3, 4 violations of Rule 1.
What's Rule 1? Don't give me these rule numbers. Just give me what the violations
all
are.
local, state, and federal law. So it's all of the new charges.
I know. For what charge? For the 25 case?
Yes. So for the original charges stemming out of Willoughby Municipal Court, 25 CRA.
So you have a you have a violation in the 24 case for the criminal nature of the 25 case. Okay, that's all I'm doing.
There's one other additional violation.
I don't care about that. I don't care. Okay, we can sit here all afternoon and go through all these things if we want, or we can get on with the business. So in the 24 case, there's a violation for criminal activity that resulted in the 25 case. Is that correct, Mr. Cherry?
That is correct, Your Honor.
How does she want to proceed on that?
Your Honor, I've had an opportunity to discuss this with my client, and we're prepared to waive final hearing and enter admission at this time.
Is that what you want to do, Ms. Facemeyer?
Yes, Your Honor.
So on the 24 case, what is your plea to the violations which came as a result of the criminal activity in the 25 case?
Guilty, Your Honor.
All right, I'll accept your guilty plea and find you guilty. Now, let's go forward on the sentencing on the 3 probation violations and the 25 case. Mr. Cherry?
Thank you, Your Honor. Your Honor, this is definitely not how I was envisioning being in front of you next time on this case. As I recall, and I'm disappointed, even myself, that we left here on a positive note with an opportunity for treatment, and we're here back again on a new case, a new charge. All I can say is that I've been involved with people that have been recovering from addiction of various kinds and various stages for a long time now. And I've seen some people get it right away and work the program and become better and stable, and other people struggle over and over and over again. Come to believe that relapse is part of the road sometimes of recovery. And it's an unfortunate unfortunate thing to understand for people who are outside, who don't experience what it's like to be subject to an addiction. Ms. Facemeyer has addressed and still struggles with and will always struggle with her substance addiction. Nevertheless, she had largely been in remission prior to maybe what happened when she was taken into jail with positive. Beyond that, she had 3.5 years after you put her out on judicial release before she got back in the system. She has been able to put together a long period of sober time. This addiction is a replacement addiction. It's the same thing that happens in your brain, no matter what your drug or activity of choice is. It triggers your endorphins, makes you excited. Your reward center lights up. That has now happened for Crystal Facemeyer with gambling, what used to be for drugs. It's nothing different. It's just a new flavor of the same problem she's had. And I know you've worked with her for a long time and given her plenty of treatment opportunities. I would just ask this court to consider NeoCap again. The last time she was there was in 2016. NeoCap is the program that is designed to address criminal behaviors and is a program that can handle a gambling addiction along with whatever might remain of her drug addiction and get her back on the path to where she is able to be honest with herself. One of the things that was mentioned by prosecution in chambers is that her honesty is an issue. Well, of course it is. She's an addict. Addicts are by nature dishonest. They have to do whatever they can do to maintain their addictive lifestyle. I'm just asking you, whatever you do for her sentence, that you consider treatment to be a significant and primary part of it, so that we don't just throw Crystal Facemeyer away. We give her at least the tools available to her that she can recover. And I'm asking this court to issue a NeoCap order, the jail treatment program, and an opportunity to come back before you in, say, a year for a judicial release hearing and possible probation.
The audience in the courtroom can feel the shift. Even the defense attorney's face says it all. They know what's coming. The judge is no longer negotiating. The decision is final, and the sentence is about to drop hard.
With IOP. Thank you.
Thank you. Ms. Facemeyer, what do you want to tell me?
Your Honor, I just want to take full responsibility for my actions this time. I understand I've been in front of you a lot of times, and this time, though, I stand before you just asking for a last chance at mercy, because I do finally have a life that you gave me when you gave me judicial release that I don't want to lose. I'm here because you granted me that chance to even go into treatment and save my life that first time, and I'm just asking for it one more time, Your Honor, please. Thank you.
Ms.
Your Honor,
Cutts?
I apologize, but I failed to ask you earlier. My client's boyfriend, Dan Blankshane, would like to be heard, and Pastor Rollins is here as well. You heard from them before.
Okay, just tell me, just state your name and tell me whatever it is you want me to know.
Your Honor, my name's Daniel, and I'm Crystal's boyfriend. I acknowledge the fact that her actions and her choices alone are the reason that we are here today. I met Crystal in the program of Alcoholics Anonymous several years ago. We were members of the same home group. We both held various service positions in the group. As I got to know her a little bit more, I learned about her struggles and her journey. I had the chance to hear her story at a meeting the first time that she gave it publicly, and it gave me a lot of hope at a time where I was dealing with a lot of personal issues. And it gave me that hope that if I kept applying myself and I kept applying the principles of the AA program, that I'd be able to overcome my circumstances and maintain my sobriety, which by God's grace I have for over 7 years. Since that time, Crystal and I have gotten to know each other very well. She came to live with me in January of 2024. We continue to attend AA meetings both together and separately. We attend St. John Nottingham Lutheran Church together nearly every Sunday. We pray together both in the morning and at night daily. Crystal has made my house feel like a home again. She's contributed more than just helping me by cooking, cleaning, and helping with bills. She's encouraged me when I've doubted. She's supported me when work has been overwhelming, and she selflessly helped her 22-year-old nephew out with money for car repairs and helping him tie up loose ends, while she's received no emotional or financial support from her own mother or father or anyone else in her family. She's been a strength and supportive to my elderly parents, who themselves have significant medical issues, offering her knowledge and certain things dating back to her experience as a registered nurse. She's been a true blessing to me and for them. I love her beyond words because I can't put into words what her presence in my and my family's life has meant. I've done everything that I can to repay that kindness and support in spite of these present circumstances. That's why I stand here today asking you for your mercy. I know that Crystal has brought a great deal of hardship upon herself. I know that every avenue has been explored and tried. It has not all gone in vain. Though her progress has been slow and has not satisfied this court entirely to this point, I have seen growth. As a recovering alcoholic and addict myself, I know firsthand not only the potential for legal consequences, for those who suffer from this disease and the choices that they make, but most frightening is the potential that any day, any time an alcoholic or addict of any sort of vice chooses to drink the drug or even something like gambling over sobriety, it could be their last. Crystal chose to accept treatment when it was ordered to her and abstained and remained free from the grips of drugs for over 5 years until these present circumstances. Each addict progresses at a different pace, and once we cross that line, everything has the potential to be just as dangerous and destructive regardless of the form that it comes in. Crystal has come to that same realization and asked me to begin looking for.
Behind the robe, remember, judges are human too. They see patterns, they see excuses, and when the same defendant returns again and again, even the calmest demeanor has limits. That's what we just witnessed. The moment patience turned into principle.
Facilities and would accept her on an inpatient basis the same day that she was arrested. I firmly believe that she has finally reached bottom and is willing to address these demons fully once and for all, but she needs that opportunity and a little extra grace in order to be able to do it. I've made several calls and tried to find somewhere that would accept her on an inpatient basis for gambling, but there is none that's been available. She has had 2 assessments that were conducted, one by Lake Geauga and one by the McIntyre Center in Geauga County, and they are unable to accept her. However, there is Signature Health, which is where she receives her psychiatric help from, which does have a gambling-oriented IOP program, as well as individual gambling counselors licensed and certified in that area of recovery. Your Honor, I understand that punishment is part of justice, but I humbly believe that restorative justice should also include the restoration of the offender. Part of that restoration and recovery from addiction is establishing a relationship with a higher power, who Crystal and I both know as our Lord and Savior, Jesus Christ. Crystal is still a young woman who has shown potential in the past. She fell into a long and dark and troublesome path and has struggled mightily to free herself, and it hasn't been for lack of effort. Addiction is a cunning, baffling, and powerful disease. It leads people like her and I and countless others down the road to ruin, but it doesn't have to be a death sentence for us. We do recover if we're willing and we're able, and when I see her, I see through the years of the struggles that she's endured, the look of defeat, the emotional toll it's taken on her. I see the woman who still has hope, who still is holding on to her faith, and who just needs a little bit of extra help so that she can live a full and productive life. One that can make us all proud. It's never too late while we're on this earth to make the changes that we want to make within ourselves. It is my prayer that you will consider this and that you will grant her that opportunity. Thank you.
Thank you.
Ronald Rollins, I'm associate pastor at St. John Nottingham, where both Crystal and Dan attend. I'm here to support her. As long as she's been incarcerated, I've continued to visit her and pray with her and to help her understand that she's not abandoned. My concern is that she feels alone. She knows that our Lord is with her, but this is a difficult time for her, I understand. But I'm here purely out of support for her and to seek the mercy of the court for her.
Thank you. Ms. Cutts?
Thank you, Your Honor. I won't go through every detail. I know this court is familiar with these cases, but I do feel I need to do a level of information for the record. So in this most recent case in 2025, defendant was going into people's cars that were in parking lots. She was checking which doors were open. When they were open, she was going in and taking anything out that apparently to get money of some sort. She was at 2 different locations on March 17th for the most recent case. One was a business. One of the employees, Tammy Orr, went out to her car early in the morning. Her items were, including her purse, were in there with her medications, her money for bills, and some shopping money. Then when she went back out around the lunchtime hour, she realized her purse was not there. It included IDs, credit cards, 4 prescription medications, and approximately $180 in cash. When I spoke with her, she indicated that once she found out and was able to see the video of a person going into her car, she felt
The lesson here extends far beyond the courtroom. Discipline, respect, and responsibility. They're not just legal expectations. They're life expectations. Ignore them, and life itself becomes the judge.
Very dirty and had to wash her car inside out. She felt very violated. She said she had $120 set aside for bills that she had looked through, and between $60 and $80 in cash for some shopping she was going to do. Mr. Butler was working. He's the other victim. His company was at a location when he left his work vehicle unlocked as he was going in between the building, and his metal folder full of receipts was taken and a bag full of checks was taken. So they both had economic harm. We'll say that Mr. Butler did get all of the items back, but at the time he was concerned for his work aspects. Ms. Orr got everything back except for the cash. That's because when the police thankfully were able to locate the defendant quickly, most of the items were still in her possession. These new offenses were committed while she was on community control in the 3 other cases we've mentioned. In the 2019 case and the 2020 case, she was on judicial release, so she had previously been to prison. And then in the 2024 case, she was on probation. She does have a history of criminal convictions. The majority of them have gone through this court. So we have the 2016 case where she was convicted of 10 counts of illegal processing of drug documents found in the 4th degree and 10 counts of forgery found in the 5th degree. She was given treatment opportunities at that time, as been mentioned, NeoCap and as well as JTP and Oak House. She did have multiple probation violations in that case, which included testing positive, being discharged from aftercare, bringing in somebody else's urine. She was ordered to Oak House and Opiate Recovery Program. Then she had new charges out of the Mentor Municipal Court, which later became her 2019 convictions for possession of drugs, a misdemeanor, and petty theft. When probation was trying to work with her for review hearing, she failed to appear. She didn't bring documents as requested, and then additional charges came through. And she also tested positive for fentanyl and opiates. She was then revoked and sent to prison. That prison sentence was completed prior to the judicial release. But in 2019, as I mentioned, she had the misdemeanor theft and possession of drugs. In 2020, she was convicted of trespass and habitation when a person is present or likely to be present, found in the 4th degree. Also in 2020, she had a separate case of burglary, a felony of the 3rd degree, and identity fraud, a felony of the 5th degree. In 2025, she has the theft, felony 4, and identity fraud, felony 5. So, thank you.
All right, I've reviewed the pre-sentence report and the record for the previous cases. I've considered what Ms. Facemeyer has had to say, what those in support of had to say, what counsel has had to say. I've considered all the provisions in 29, 29, 11, 12, and 13. So this, in our history together, this is case number 5. One of them is done, the 16 case. The others, you've been given opportunity after opportunity after opportunity for treatment. And then this last case doesn't involve something as damaging yet innocuous as failed drug tests. It involves going into other people's property and stealing from them, taking the opportunity on numerous occasions and breaking into people's property. So based on the totality of the history here, I'm going to find you're no longer amenable to community control. On 25, 368, on count 1, I'm going to sentence you to 30 months in prison. On count 2, 12 months in prison with credit for 24 days, restitution to Orr in the amount of $180. On the 24 case, on count 1, I'm going to sentence you to 12 months in prison. Count 2, 12 months in prison, credit for 1 day. On the 20 case, I'm going to sentence you to a term of 18 months in prison with credit for 78 days. And on the 19 case, count 1, 18 months in prison, count 2, 12 months in prison. Each of the multiple counts in the 19 case, the 24 case, and the 25 case will be concurrent to each other, and each of the cases will be concurrent to one another. Costs are assessed on each of the individual cases. When you get out, you might be on post-release control for up to 2 years under the parole authority. If you are placed on post-release control, they will impose conditions upon you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation, a maximum of which is the greater of 12 months or the time left under post-release control. Is there anything further, Ms. Cutts?
Yes, Your Honor. Some of it may have been what I missed. The 2019 case, she was originally sentenced to 36 months on count 1
Right.
and 6 months on count 2, so that would need to be reimposed as it was.
All right, I'll give her 6 months on count 2, 18 months on count 1.
I have a brief moment, Your Honor.
Okay.
I believe that's all, Your Honor.
Mr. Chair, anything further?
Just a couple of brief things. One, Your Honor, I know we filed a motion for the administration of gabapentin, and I know that was denied. There is also an issue with Lamictal and Zoloft, as I understand it. My client isn't getting it as she's prescribed. Could that be addressed? It was my understanding that was brought up at the prior hearing, but I wasn't here. No?
It was not, I'm not.
No, it started to be brought up in chambers, and you had indicated that you had dealt with that, and that it would have to come up later and.
All right,
But
so
you would ask for
that,
paperwork.
that motion was filed,
The
right?
gabapentin motion was filed.
Okay,
yes.
I'll have to take a look at it, because there are certain drugs they will not administer in the jail. Yeah,
Well, I'll tell you, I found gabapentin on that list.
okay,
I'm not going to lie about it, but I filed the motion because she has prescribed it.
okay.
And I'm not sure about Lamictal or Zoloft, if they're
All
on
right.
the list or not.
I will take a look at the motion, because I know you filed it, but we didn't.
If you found this breakdown powerful, hit like, share this video, and subscribe for more real courtroom moments that reveal the truth behind justice. Because sometimes, what happens inside that courtroom teaches us more about life than any textbook ever could.